you know? Half the town's drunk, you know, lying in the gutter. So you guys are listening to a lawyer of all things, man. Jesus, 8 o'clock, you know? I see these guys coming back, throwing down, chugging. So you're here. So believe me, I mean, I say that, I'm joking, but I mean, the fact that you're here, I mean, it says a lot. You know, there's a lot you can be doing. You could be watching television. You could be at the bar. You could be smoking dope. I mean, whatever, you know. So you're here. This is a great start. If you want to succeed, this is a non-legal tip. You got to hustle. You got to really, you know, you got to want it. I mean, everyone says the same thing. Paul Graham, it's determination. Anything you do, you have to work hard to succeed. It's desire, and that's what it's all about. So getting back to investors, often what happens is you can't find anyone, and so now you're scrambling. You end up not selling your stock, or you end up selling shares to non-accredited investors. So that's the buzzword. That's the only thing I'm going to discuss for the next 2 minutes. You want to get investors who are quote-unquote accredited. Accredited investor. That's the term that the SEC uses. So what the hell is that? It's someone who has a net worth of $1 million or more, or they've made $200,000 a year for the past 3 years, or past 2 years, and then they have the expectation of making that much this year. Okay? They tried to change it. You know, Senator Dodd, and when they were doing this Dodd-Frank bill, they tried to really up the ante to about $3.6 million, and I think about $460,000 a year. And there was tremendous pushback. You know, a bunch of people, including myself, really pushed back hard. There still may be changes, but that's not that big a threshold, honestly. The one change they did make is, in terms of the net worth, with $1 million, you can no longer include your primary residence. So they pulled that out, so that obviously hurt. But there are a bunch of people out there, believe me, particularly up in Silicon Valley, San Francisco, with a lot of money. There's a tremendous amount of money on the sidelines here, folks. Unbelievable amount of money. I can't emphasize that enough. I mean, I see it every day. You hear the stories. Valuations are through the roof. There's money out there. So you just got to go out there and hustle and really impress people and deal only with accredited investors. Because if you don't deal with accredited investors, you got a huge potential problems. And that's really the mistake. You know, people reaching out to friends and family. There are ways of doing that, you know, with the securities laws, particularly in California, but it just opens up a Pandora's box of potential problems and disclosure issues. And it's really not appropriate. What the SEC is saying, what they said back in 1933, when the Securities Act of 1933 was enacted, is it's not appropriate for someone making $40,000 or $50,000 a year to give you $25,000, right? That's why these laws are enacted, and that's why they've developed over time. I mean, you know, if you think about it, it's not appropriate for, you know, your neighbor who's making $50,000 a year to give you $50,000. So what they're saying is deal with the rich people. You don't have to present them with what's called a private placement memo if you deal with them. There's no disclosure requirement. But when you're dealing with non-accredited investors, there's a significant amount of disclosure that you have to make to them, and that could be $20,000 drafting these private placement memorandum. I've done them. So that's really mistake number 5. Yeah.
Can you explain why does the SEC consider that illegal?
Because they're trying to protect the little guys. So after the crash of 1929, there was an extraordinary amount of hearings, sort of similar to what happened with the recent financial crisis. And the gurus got together and they said one of the problems was that there wasn't, we didn't protect the little guy, the little person. And so they came up with these thresholds over time, the most significant issue being this disclosure issue, that in order for somebody who doesn't have significant amount of money to make an informed decision, it's the issuer must present them with all of the relevant, all material information. And so that's where you get these sort of private places.
What if you're not a corporation? Is that only if you're a corporation?
Any entity that's issuing securities, which is very broadly defined, must comply with the securities laws. And so if you're not, one of the great things about dealing with only accredited investors, not only is there no requirement, is there not a requirement to provide them with disclosure. Some people would want to do that just to protect themselves. But also this special rule 506, I don't want to get too technical here, but it preempts state law. And so if you're dealing only with accredited investors, see the other issue, it's not only federal law that you have to comply with, but each of the states. And every state has a different set of laws. They're called blue sky laws. You might have heard that term, blue sky law. And so when you're dealing with 1996, Congress said, this is crazy. How could we comply with 50 states? And so this 506, Rule 506, preempts state law. So if you're only dealing with accredited investors, all you have to do is if your investors are located in different states, you just have to file what's called a Form D. If they're non-accredited, here's what happens from time to time. You got Uncle Charlie in Washington. You have the two people you went to college with in New York and Florida. You have, so at the end of the day, you got 12, 15 investors in different states, non-accredited. Not only do you have to comply with SEC, but you have to comply with each state. It's crazy. I mean, you're going to spend $20,000, $30,000. So that's why you only want to focus on accredited investors. Yes?
So, if I have a friend that actually qualifies for this or relative, so all they have to do is file the form and that you're good? Or if they live in a different country, I mean...
Yeah, and so I don't want to spend too much time on the securities law. It's very complicated, but the bottom line is what the SEC and the states say. Anytime you're issuing securities, very broadly defined, it includes convertible notes, converts common stock, any profit participation. What the SEC and the states are saying, you have to register with the SEC and register basically with these state commissions unless there's an exemption. And one of the most common exemptions is called the private placement exemption. Just like the name sounds, it's a private offering. It's 2 or 3 people, 7 people, 10 people. And that's where we get to these accredited investors and these set of rules like 506. So to your question, it's a little more complicated than that, but you would sit down, presumably with counsel. And by the way, this is the one area. You want to play lawyer and everything, play lawyer, good luck, but do not mess around with the securities laws. I mean, this is just no time to be pulling forms off. I have several calls over the past year. The SEC in the states now are just going crazy. I mean, the pendulum has swung so far, it's just outrageous. Because of Madoff and all these other guys, these crooks, you can read in the paper. I just saw 3 SEC actions today. I mean, they're looking for, the poster child. And so we're not just talking about, so what happens if you get caught? Here's what I hear all the time. Who's going to get caught? Everybody does it, right? Well, that's not really a reasonable position, right? You're going to knowingly break the law. And so what happens is, and I've seen this many times, the SEC or the states will come in and say, here's what you got to do. You got to do a rescission offer to your investors. All the people who gave you money, they have the right to get their money back plus interest. Well, think about that. Plus there may be fines, plus there may be penalties. Plus, if it's really, really egregious, they're going to refer it to the U.S. Attorney's Office. There's possible criminal violation. So don't mess with the securities laws. Anytime you're taking other people's money, you got to get a lawyer involved. I mean, it's just the way it is, whether you like it or not. I'm sorry. Does that answer your question? Okay, good. Foreigners often are not necessarily subject to U.S. securities laws, but the issuer would be. So, yeah.
Let's say you do something like Kickstarter where you get people that you know to invest through there, are you...
I'm sorry, Kickstarter?
Kickstarter.
Oh, Kickstarter.
If you get them to invest through there, are you shielded from that because it's considered a contribution, or how does...
Yeah, I'm not all that familiar with Kickstarter. My understanding is you're just making a contribution, right? It's like a gift. Yeah, they're not selling a profit interest.
Right, so it's basically you're offering them something. It could be a T-shirt or whatever, but...
Yeah, what are you offering them? A gift back?
Some prize or something as a thank you.
Oh.
It's not an actual exchange.
Yeah, I'd have to study. I mean, this stuff's very complicated. I used to do, as a first, second-year associate in New York, you had all these complicated... So the SEC has what's called, you may have heard, these no-action letters. And so often in very, very complicated securities issues, and I used to draft these as a young associate, you actually send a letter to the SEC, here are the facts, and we want you to basically issue a letter saying that you're not going to take action. That's what it's called, no action letter. So you'd have to spend hours, going through all these different letters. Does this fit? Does that fit? To try to advise the client. And so I don't know enough about Kickstarter to start. There's a bunch of sites out there now that are doing things. At some point the SEC is going to crack down on these websites. There's a whole bunch of websites out there now kind of playing matchmaker. I would just be careful with them also because there's an issue of being a broker-dealer. There are other issues associated with that. Here in California, I don't want to spend too much time. This is my final comment. I came out from New York, and there's a whole bunch of people, and you got to watch out for these guys. They sort of play like finders. They'll say to you, hey, give me 5% of any money I raise for you. Okay? That does not work unless they're a registered broker-dealer. That's really important. And California has its own separate state laws. So you want to run the other way. Doesn't matter what they call themselves. unless they're actually registered with the SEC as a broker-dealer. It's very simple. Hey, are you registered as a broker-dealer? Oh, they'll come up with 50 excuses. You can't give them 5%. You can't deal with them, and that's just the way it is, because then your private placement is negated. So, so that's it in a nutshell. I probably have all your heads spinning. We're ready to drink some beer and have some pizza. Any other questions? Yeah, do you have them in the back? No. Oh, okay, just stretching? Just stretching. Very good. You're trying to throw me off here, huh? Yes?
I got a question. So what if you have a situation where you have some minority partners that are like real small, and you started off with too many co-founders.
Right.
You got everybody's at 20%, and you got a couple onesies, twosies, and you want to get investment. And I know that VCs aren't going to want to deal with 6 founders or 7 founders.
Right.
8 founders. What's the best way to get rid of them? You can't force them to sell.
I know these guys in New York, man, for the right price. No, I'm kidding. You just got to, this one's hard. That's like the guys, I get these calls, as I said earlier, my co-founder left and he has half the company. What do I do? It's like, what do you do? You got to, get a beer.